Well, a very good day to you, ladies and gentlemen. Welcome to Kenya's most comprehensive political analysis show here on Professor Herman Manyora's YouTube channel. Well, of course, my name is Evan Sokinyi. Such a pleasure to have you on board again on another interesting episode of the Candy Talk. As usual, I'm here with Professor Herman Manyora. How are you, sir?
I'm doing good. Yes.
Still looking great. And of course, I came here. I didn't see you around. It seems like you're back to the TV stations.
No, not really. Not really. Once in a long while.
You're back to taking tea, so they say.
Yes.
No, let's have it this way, Prof. Recently, I've been looking at how things are taking place in the country with regards to the cost of living and all that is taking place within this country right now. The cost of living is still high, yet it does not form a bit of the conversation as it used to do back then. People are not talking. I wonder where the silence has come from. But of course, what has triggered this is the recent determination by the Supreme Court that just decided to uphold the ruling of the High Court, the Court of Appeal, that actually suspended that conservatory orders that were put on the implementation of the Finance Act 2023. And here we are, these things are taking place here. The Act is here with us, and Kenyans are still feeling the pinch of the cost of living as it is right now. One, I would like you to perhaps give me your feeling about the decision of the Supreme Court to actually fail to grant Okiya Omtatah what he wished for.
Well, you know, things that are in court, you expect either to win or lose.
Yes.
And in this case, Okiya Omtatah lost. The case is still in court, of course.
Definitely back to the
orders to stop the implementation of the act, which orders had been given by the High Court and stopped and lifted by the Court of Appeal, that Okiya Omtatah was taken to the Supreme Court. The Supreme Court said no. And I think they dismissed the case on mere technicality.
Yeah, definitely.
If we are to believe Okiya Omtatah, he had been asked to file a 15-page document. I think he went beyond that. We don't know by how many pages, but it was dismissed, I think, on that ground, on those grounds. Yeah, so we'll need to wait and hear the substantive case at the Court of Appeal. Yes.
Now, here we have definitely Kenyans. This is something that affects the lives and livelihoods of most of the Kenyans. And if you're talking about those technicalities therein, of course, I understand that a number of these submissions are also done a little bit late. I wonder whether the Supreme Court should actually be minding about the effects of the implementation of the Act to the people of Kenya, or concentrate more on the technicalities involved therein.
The Constitution itself, as Okiya Omtatah points out, is very clear in terms of where you place procedural issues, technicalities, vis-a-vis substantive justice. If you feel substantive justice will be compromised, if you foreground technicalities or procedural issues, then you ignore the procedural issues or technicalities and deal with the substantive issues. But you see, our courts have not been very clear on this issue. In 2013, Raila won petition against Uhuru Kenyatta. The case was lost on mere technicalities, on procedural issues. So I don't think I've seen the court embrace that provision in the Constitution. They have not been able to embrace it. But while at that, I also want the courts to be clear about certain things. For example, to tell lawyers, you cannot just come to court to speak English from morning to evening. You have specific time. And if you are filing documents, there must be a limitation to just how many pages you can file. You know, how many words. I think words are even better than pages, and so on and so forth. So it's a good thing that the courts are trying to implement that. But when you use a case of this nature to implement what you have not been able to implement where it mattered most, then people are left wondering. Yes.
Look at our justice system right now. Is it working or not? Because we've had this kind of scenario. We've had these statements made by Okiya Omtatah immediately after the ruling was made by the apex court of the land, and of course that saw his case being thrown out there Then he made these statements which did not actually sit well with the judiciary, and of course he got warned of making some sort of so they called derogatory statements against the bench therein. He is talking of the judiciary perhaps relying, or rather following in, or rather bowing to the plea of the executive arm of the government. I wonder whether that is perhaps a little bit true. But if at all those statements by Okiya Omtatah are anything to go by, then what could we be facing here as a country when, if at all, the judiciary decides to succumb to perhaps pressure
but
from
you
above?
See, you see, I don't mind people talking things about the executive, the judiciary, so long as they are not insulting the judges, they are not demeaning the judges, they are not compromising the dignity of our courts. Criticism is okay. Another thing that I think both the judiciary, the general public, and the executive, and anybody who cares to know should know, is that there's always a pull and push in any country with a functional judicial system. The executive is always trying to have influence over the judiciary. Parliament is always fighting with the judiciary, or sometimes even going to bed together. This is it's normal. It shouldn't worry anybody. If in the course of business we see the judiciary seem to be pandering to the wishes of the executive, it shouldn't surprise us. We should just expose it through judicial arguments. Yeah. And say there's no way this case could have gone through unless there's another hand. There is a country in which I saw, I think in Nigeria or something, maybe, there are also Photoshop and what have you, but you can use that to demonstrate whether it is materially right, correct, or wrong, whether it is fact or otherwise. Where there was evidence that the judgment in the just concluded petition against the victor of the president of Nigeria seemed to have been written by somebody in the office of the president. Of course, it can be a Photoshop, but the point is those kind of things are possible. So then you expose those kind of things. So long as we do not allow ourselves to be lazy, we should not be worried if the judiciary goes to bed with the legislative arm or the executive arm or anybody else. Our work is to argue our case well, and after the verdict, move to the next level of the court, and when it's no longer working, we try to expose the rot. I heard so many people say there was a case, a very serious case, and people argued money had changed hands, judges had gone to Dubai, but that's just hot air. Why don't you expose the facts? Yeah. So nobody should get really overly worried or surprised, for that matter, that the judiciary could be pampering the whims of the executive. Yeah.
Now, in the most recent held meeting, of course, there was a judges' colloquium that was held, and of course, the Chief Justice speech was read by her deputy therein, where it was very clear the kind of message that the Chief Justice was sending out there to the government, saying that leave the judiciary alone. They've decried a number of issues pertaining to how the judiciary is run in this country, and of course the issue of funding has been at the center of it all along, where actually it's said that this actually undermines the independence of the judiciary, because they have to depend on the executive arm of the government to release the money to them. They're saying here that they've experienced a lot of hurdles coming from the exchequer, and they're here lamenting that some of these things are actually going to affect their functions. When the president came on board at the time, he said that he wants to actually make sure that the judiciary is independent. He wants to grant them that kind of autonomy so that they operate on their own. Yet they are here crying foul right now. Do you then think that perhaps some of the things that can actually interfere with how justice is delivered in the country?
Of course. But why trust a politician? A politician will promise you this, and they get power, they don't do it. So they promise to make the judiciary independent by way of funding. That was just talk from a politician. Yeah. And then the politicians just talk. So if anybody was placing so much premium in that, then they should be advised next time not to. Because when I heard the judicial lamenting from Mombasa about money, I said, but we were told they are going to be independent. The government was going to implement the judiciary fund and give them independence and etc., etc., etc. But that's normal. Politicians are the same people all over the world. Yes.
So yeah, we witnessed this problem the other time with the former president actually failing to appoint a number of judges. And when the now president, of course, William Ruto took over, we saw a complete departure of what used to take place back then. In fact, those judges were appointed immediately without having to look into much, let me say, per se. And we thought that that was the beginning of seeing great change in this sector. Right now, here we are looking at this. Where does this leave the judiciary? Or rather, which options do they have right now that you've just told me that they're dealing with politicians, that they know that politicians are not supposed to be, perhaps can't be trusted every day?
But appointing the 6 judges immediately after taking over was just a populist move. Governments don't work like that. No. Governments exist in perpetual succession. When you take over as a chairman of a company, you are not creating a new company. You are just occupying an office. And the omissions and commissions, assets and liabilities will apply, irrespective of who is president of Kenya. So when you find 6 judges not appointed by your predecessor and immediately appoint them, it doesn't speak to prudence. Because unless you are just being populist, why don't you take a little time to find out why your successor didn't appoint these people, your predecessor? Yeah. And you can see I'm right, because it's not long. And now we can see everything else was just talk or populism. Yeah.
And here we are back again.
Yeah. So you better place your trust in institutions than persons. And if you take over office anywhere, don't always act, at least not so fast, not immediately, in a manner to suggest the people you are taking over from were useless. Unless you are coming in with a revolution, then you can overhaul things. But if you are just coming in, you've been elected president, you've been appointed chairman, you've been appointed CEO, the worst mistake you can make is to come in as if those who are there never did anything. They knew nothing. But the only time that is allowed if there's a total overhaul through a revolutionary wave, a complete change of things, then you can come with your new ways of doing things. But if you are just coming in a normal way, and you have been elected president, you haven't taken over power through the other means, you have to be very careful. You have to find out why the other guy didn't appoint these 6 judges. Take your time.
Do you think we have a long way to go in terms of our jurisprudence and its growth therein, and how we can actually make sure that our judiciary is fully independent? Because I'm still looking at a situation whereby things could actually happen in Kenya as they do in South Africa, or as they do in other countries, whereby even the former presidents are recalled and taken to court. Look at what is taking place in other countries, and is that really possible in Kenya right now?
Yeah, but you see, our circumstances inform our actions. So you cannot expect a judge to operate in a vacuum. Our history has a bearing on what we do today. But even before you go into that, we have to accept that compared to the judiciary of Bernard Chunga, of those days of Bernard Chunga, of those who were Zungu judges, we have come a long way. The sort of independence we are seeing today, then it was just a dream. Because they didn't even hide the fact that they were working for the president. They even wrote documents to defend that position. There's a particular judge who was written somewhere and said, I can't remember his name, that commonly judges who came to assist new found nations in Africa had to be sympathetic to these young nations. And the judiciary will be put to the use of the president. Otherwise, the government will collapse. They didn't even hide it. We are talking of days of direct telephone calls from State House and you are dragged to court at night. So you cannot say we have not moved. We are coming from days when the judges and the other judicial officers of the court, transformed themselves from ordinary people to extremely rich billionaires overnight. Days when bribes were commonly given in bars and hotels. If you saw a magistrate having a drink with guys there, just throw your eye from your table and you'll see money. Just he's being given money, ukiona. We have come a long way. We've come a long
way.
But there's still a long way to go. The judiciary can improve, can do better. I think what we require in the judiciary today is an outside view. I don't know how they can cause this to happen, so that people like Manyora and others can help the judiciary deal with the issues that are bogging them down. Approach the management of cases within the court, for example, is something very close to my heart. It really affects me to know that there are men and women who stay in remand prison. They can't be given bail. They are given unreasonable bail terms. Their cases can't be concluded. Lawyers take unnecessary too many cases. They jump from one courtroom to the next courtroom, and all they are doing is asking for adjournment after adjournment. I think that will require an outsider input to help the judiciary of this country come up with a way of managing cases. And I've given an example. If you go to hospital, you don't always see a consultant. You are clerked. You see clinical officers or people like that until finally, progressively, your case then lands on a consultant's clinic. But here, you'd go to the High Court, you go to the Magistrates Court, and the case is admitted immediately, and then it takes 10 years. Maybe this case would not even have been heard in court. Maybe there would have been better ways of dealing with it, and that's what the judiciary needs today, to be proactive. I want our judiciary to stop hiding in the adversarial system. They don't need to move to the inquisitive system that is associated here with France, but they need to be more proactive. They need to establish structures that can interrogate cases as they come in, especially civil cases. People are arguing over a piece of land. Maybe if you went to the ground, you'll find, like I've given examples elsewhere, that case should just be dismissed immediately. Yeah, people are arguing, this is not my brother. We are inheriting, this is our property, but this man is not our brother. Yeah, alikuja na mama. But that's something the court can decide one afternoon. You call the government chemist and ask them, can you help us do the DNA of this guy? But you see, that alone can take 2 years. So I'm saying the courts will have to be, beyond the other issues they have, know how to manage cases.
Okay, well and good, ladies and gentlemen, allow me to stop this conversation at this particular moment, but please do weigh in on this conversation and tell us if at all you think that perhaps the judiciary in this country can work and function well without any interference from the executive arm of the government. Till we have this conversation again, have yourself a lovely day. My name is Evans. Okay.